Hey everyone, Harry here. I did another explanation of the U.S.'s response to Comey and James's motion to dismiss the indictment because of Halligan's improper appointment, they allege. And now the big other response today, it was submitted yesterday, but we've just been able to see it this morning, is the response to Comey's motion to dismiss the indictment based on vindictive and selective prosecution. First thing I want to say as to both the responses, the U.S. has brought in what remains of their A team. This happens sometimes in big cases that sort of appellate or writing specialists are commissioned to lend a hand. The other one in the Halligan dismissal was by Justice Thomas Clerk, who's been working in the Office of Legal Counsel. That's a far stretch normally to bring someone from there to litigation. But they did, and maybe here as well, because we have a fairly sophisticated brief. It is signed and submitted by the two North Carolina assistants who were the only people, apparently, or they were the two that Halligan was able to drag in from afar to sit at Comey's arraignment and to help handle the case. It apparently being the case that nobody in the Eastern District of Virginia wants anything to do with this stinker of a weak and obviously political case whatsoever. But point one, they've made the best of a bad case with a fairly tight, if long, response. The second point, I've been saying this from the start, anticipating it. I gotta say, I'm not sure others have, but there's an inherent problem in Comey's papers, or a weakness. I'm sure it's a strategic choice. But they sort of, we all know the situation. It's really straightforward. Obviously, Trump ordered this indictment and prosecution, knowing nothing about it, because he wants reprisal against his enemies. But the law has different ways of getting at that overall problem. And instead of choosing one and going with it, Comey's papers have a little bit of vindictive prosecution, a little bit of selective prosecution, a little bit of straight up Constitution that's a violation of due process or equal protection. And as I anticipated they would, the United States exploits that sort of amorphous or hedging the bets presentation by taking it one at a time and saying this doesn't fit exactly, that doesn't fit exactly. And most importantly, point three is the difference between vindictive and selective prosecution. And at least as expressed in the tests under the law, vindictive prosecution is one in which a prosecutor punishes the defendant for the defendant's exercise of his constitutional rights, maybe having to do with motions they've made in court or refusing plea bargains and the like. But if that's the idea, selective prosecution, which is the term I've been using, that I think is the best fit, albeit imperfect, is when you have a two-part showing. One, similarly situated defendants have not been prosecuted, and two, the prosecution is for improper reasons, and without a doubt, political animus counts as an improper reason. And I've gone for that rubric and analytical framework because I think it highlights what is really rotten about that second part of the test, which is that this is being done at Trump's command and for improper reasons. Okay, but just notice, without belaboring too much, that neither is a perfect fit, because if you talk vindictive, well, it's the prosecutor who is doing it out of animus of the prosecutor for the exercise of constitutional rights. And to sort of shoehorn the case into that, you have to say it's being done for Comey's, say, public First Amendment protected statements. Maybe, but it just seems a more generalized animus based on everything. Whereas in the selective prosecution side of the ledger, you've got the cleanest fit of what's really going on here and what's really rotten and unconstitutional. The selection of him by Trump to get back at him. But it gets tricky to show similarly situated defendants were not prosecuted, both because there are some prosecutions of higher officials, very, very, very few to be sure, for perjury or false statements to Congress. But it also seems like, it's a very rare selective category. And when it does happen, you can imagine the administration will charge. But in this kind of case, if you're really taking seriously, and I suspect Nachmanoff will, what similarly situated means, then you have to bring into play that his statement is basically true and nobody would care anyway, and it was completely confusing. And you sort of package that in the showing of whether similarly situated defendants have been prosecuted. Okay, but to go to the administration's arguments, I mean, they're really tenuous on the facts, and it'll be quite interesting given the really diametrically opposed factual presentation. I would think the table is really set for Nachmanoff to order discovery, which the administration is loath to provide, especially as it concerns Lindsay Halligan, who was kicked into the grand jury room, received some kind of orders or understanding from Trump, has to be the case. And in the other proceeding involving her appointment, the administration was ordered to submit grand jury transcripts, and they just didn't include her statements. The judge immediately said, "You've got a day, give me her statements." But obviously, that's a point of vulnerability. The actual, obviously, very likely, given that she's, a complete amateur who just stumbles in with instructions to bring Trump the heads of Letitia James and James Comey. Okay, so otherwise we have a well written, but when you just look at it and get to the nub, very implausible brief on the facts. So their main point that they want to make is to say, well, yes, Trump did these social medias where he said, justice must be served, and he said nothing about the crimes. But, that doesn't mean that that the reprisal was his actual motivation, and they need to have some direct evidence of that. And this isn't direct evidence. I don't know what would be more direct than that, but it's just, sure, he said that, but we have an independent U.S. attorney, who and a grand jury who made the decision. Of course, that's always the case in these kinds of motions, but and for a selective prosecution, and it doesn't launder it that it happened. But so that's one. You can't really show it. And of course, even though he said these things, what he really was saying is Comey had committed crimes. So that's the reason, whatever crimes, I don't know. And then he makes a statement about how Halligan will make the decision, and that supposedly breaks the causal chain. So that's a, just I would say, incredible and disingenuous submission, but presented in its tidiest possible form, and against the backdrop of a law in this area that really, really requires that the showing be quite strong indeed. So that's their main point. But to me, at best, it would lead to Nachmanoff ordering discovery. The second main thing they do, and we'll be unpacking this for a while, and I hope to actually be at the hearing, but the other major point to leave you with, and then I'll be returning to the motion for sure, is there's a long recitation of Comey's exchanges with person number 3 in the indictment, Dan Richman, a professor at Columbia. And while it's irrelevant to the vindictive prosecution motion, the vindictive prosecution, if that's the reason you're doing it, is a due process violation without regard to the strength of the evidence. But they give a long kind of preview of their case, and it indeed involves a lot of back and forth between Comey and Richman, and obvious sort of coordination about what Richman would tell the New York Times. In other words, evidence you would use if you were trying to say that the 2017 testimony, that the supposed false statement here is saying, I stand by it, that indeed back then he was coordinating with someone from the department. That's a separate legal issue, but Richmond has a kind of special appointment at the time, and they were dealing with the New York Times now. Very importantly, however, many of Richmond's statements in their brief come after Richmond already has resigned from the FBI. And the question posed to Comey was, did you ask anyone, tell anyone at the FBI about this? So that's really dirty pool, and I think more generally demonstrates the whole point of these chunks of evidence is to dirty Comey up in the public eye more than make a solid argument directed at Nachmanoff that this isn't a selective prosecution, which doesn't really turn on the strength of the evidence in any event. A couple quick points here. First, that doesn't get at the statement, which is, I stand by my testimony, and as Comey recently has argued, is literally true. And second, this is, I can tell you as a, Washington veteran, what they're showing is gambling in the casino happens all the time, that there's coordination with the press, etc. But to the uninformed, it's worth noting that it makes Comey look like, not a choir boy, it's true, and someone who was focused on responding to the press. And this is about the whole, Hillary Clinton, both the Hillary Clinton email stuff and the infamous meeting with Trump, where Trump tries to strong arm into a pledge of loyalty. So it understandably caused him to look to his friend and counselor, Dan Richman, but they've now gotten discovery. I don't know if it'll be admissible, if there's attorney-client stuff, whatever, but they've made it see the light of day. And even though it's not directly responsive to the motion, it does give some heft to the basic charge that they would prove at trial, not in this motion to dismiss, that, yes, surprise, surprise, gambling in the casino. Richmond and Comey were thinking about this, working it through. Again, doesn't say that what he said in the actual alleged false statement, I stand by my testimony, is itself false, but it gives rise to a sense that, this basic question about total candor in front of Congress, maybe has something to it. For many legal reasons, that's secondary, but this isn't all about the law. In fact, it's hardly at all about the law. So much of it is about PR and the like, and you can take this as a sort of dirty blow PR-wise to get it all in, but one that, it has to be said, shows Comey and Richmond, maneuvering, thinking about dealing with the press, saying off the record and that sort of thing, as happens every day in Washington. Lots more to come on this. For now, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.